Let's start with some information about recent developments, because things are happening at quite a speed right now. On Thursday last week, the Court of Justice, in a preliminary ruling, issued under a fast-track procedure that Lithuanian laws prevent illegal migrants from applying for asylum and allow putting them in automatic detention, and that this runs counter to EU directives. Both the detention of illegal migrants in times of war, during a state of emergency, or an extreme situation on the sole ground of being in the country illegally, as well as denying them the possibility to apply for asylum, run counter to EU directives, the court concluded. But here comes the interesting part. The Lithuanian Interior Minister, Agne Bilotaitė, commented the ruling by referencing national security and clearly stating that, and I quote, "Lithuania will certainly defend itself if such threats persist," end quote, and that the country would not apply the ruling for now. She added that the current legal regulation on illegal migrants is impracticable, and Lithuania is seeking to change the rules. Finland is preparing a revised border law, which a majority in the parliament want to enable full closing of the border with Russia. Recently, the Finnish government asked the EU Commission if this is allowed under EU law, and the answer was no. The interesting thing here is that the Finns would have none of that. They intend to enact legislation to protect itself from Russian hybrid warfare through the weaponization of migration. So what we're seeing here is basically that cracks on the wall are developing. EU legislation is increasingly regarded as illegitimate and outdated by the center-left, as in Finland, and the center-right in Lithuania governments. Part of the reason is the contradictory nature of legal rulings. In the famous ND and NT versus Spain case of 2014, the ECHR ruled that because a group of illegal migrants had not used the opportunity to pass legally, the Spanish government could deny their asylum request en masse and deport them. ECJ and ECHR cases are now clearly contradictory, and the EU's rules seem to be extra restrictive. I believe the ECR should look at ways to, 1, analyze the rulings and its possible consequences, as well as the consequences of other migration cases, such as the ECHR ruling on the Rwanda flight from the UK. 2, examine to what extent there is left-wing judicial activism or collusion with pro-migration activists taking place at the ECJ and the ECHR. 3, look to reform international treaties. Member states and the EU are party to or to nullify the effect of certain provisions, which the UK is planning to do with regard to the ECHR. And 4, like the Sweden Democrats proposes, to seek swift and successful negotiations, justice and home affairs opt-outs. So, for example, my country, Sweden, follow Denmark and also differ from EU rules and regulations governing migration and asylum. This could be a model for more countries.